Welcome to everyone who's joining us today for our webinar discussing the roadmap to remediation in the context of the wages underpayment issue. I thought I'd just start by introducing myself. My name is Stephanie Davison. I'm a partner in the corporate M&A, ECM and fundraising group here at Clayton Utz. And I've been asked to moderate this session. I don't profess to be an expert in this area, but I certainly have been having a lot of conversations recently with my boards and senior management team on these issues in the context of fundraisings and acquisitions and how to deal with it. So I'm certainly interested in the topic and interested to hear what the panellists have to say. I'll quickly introduce our panellists and then we'll jump into the detail of it. So Christy here with me is a partner in our workplace relations, employment and safety team. So Christy's done a lot of work and I constantly call Christy about this issue. So I'm helping people understand the risks and the issues for their business associated with underpayments and also helping them develop strategies to investigate, remediate and deal with regulators in this issue. And Christy is a bit unique in that she's actually acted on both sides of the fence in relation to these issues. So she has assisted the Fair Work Ombudsman as well with one of their first successful sham contracting prosecutions. And obviously the issue of contractors and permanent employees comes up a lot in this issue as well. So Christy has some insight into the way the regulator thinks on this topic. Secondly, we have Deepak. Deepak's a director in Clayton Utz's Forensic and Technology Services team, and he leads our data analytics capability. So he specialises in the technical analysis of large electronic data sets, and he has a lot of experience in utilising data capture and then analytically modelling that. So Deepak has done a lot of work in this area as well because ultimately getting to the bottom of this issue is a combination of legal analysis as to what award applies or and what those awards enterprise agreements actually require, and then of course being able to mine all that data to find out if there is in fact an issue there. And then finally we have Amber Augustin. So Amber's a partner in the tax practice of Clayton Utz, and she specialises in tax remediation and regulator engagement because a lot of resolving these issues actually involves regulator engagement, and she also has a practice in tax disputes. So Amber works collaboratively with Christy and Deepak when we do these engagements, and she looks at particularly in relation to those employment-related taxes, so superannuation guarantee, PAYG withholding and payroll tax. So welcome to our panel. So we've got a pretty tight time frame today. If you send through questions, we will try and make sure they're addressed. So send them through as you have them to mind, but hopefully we'll cover a lot through the discussions. So clearly in this area, the risk climate has changed. You would all be aware of that. It's been in the media, it's been in the newspaper. We have states, Victoria and Queensland, that have introduced wage theft legislation that has criminal penalties, where it's been deliberate or fraudulent, that it has jail time potentially associated with it. Unions are calling for how the police get involved in these issues, which is, quite now not only you've got another regulator effectively potentially to deal with through these issues. And the police don't have a lot of experience in white-collar crime, which is probably where this would fit. So, dealing with them will be an added complexity. We've also got the ATO, who has increased their surveillance and scrutiny in this area. And some of their administration policies tend to suggest that they're looking to impose harsher outcomes on non-compliance, which Amber will talk about through the session. And then, of course, you've got the superannuation amnesty legislation, and that has fallen away in early September this year. So you've now got mandatory minimum 100% penalties imposed on employees who didn't come forward during the amnesty. So there's probably managing those penalties will be tricky. And then you've got self-reporting with the Ombudsman, Fair Work Ombudsman as well, and how you deal with that in a way that ensures either no prosecution or minimisation of any penalties. Okay, so if we move on to the questions, so I think from my mind and from what potentially you've seen, I think, you know, if you don't know you've got a problem, you probably do have a problem. I mean, most people, when you investigate this, find something, right? Because as we know, it's also complex. So I suppose, Christy, if I can hand over to you. So either you don't know you've got a problem or someone's complained about some payroll issue or some compliance. What do you do? What's the first step?
Thanks, Steph. Well, I think the very first step, and I'm assuming in this particular climate, as Steph's already said, we've got that increased risk climate. I'm assuming that most employers are at this stage doing regular audits of their payroll, running compliance checks, looking for the appropriateness of their annualised salary arrangements, particularly since the introduction of more stringent provisions in modern awards around annualised salaries in March this year. So assuming you're doing that and you find an error or you find an inconsistency, or alternatively you're not doing that and an employee has brought a concern to your attention, the first thing I would really be thinking about there is the value of legal professional privilege. Should you be seeking legal advice not only to assist understand how that audit process or the compliance check should be undertaken, but also in a bid to capture the outcomes of that forensic review? And this is where our team and Deepak's team and Amber's team work really closely together to give that initial advice about how the process should be run, how that investigation should be undertaken, what additional information is required, and capture the results of Deepak's forensic review of the information as part of the overall advice that can be provided to our clients to not only identify how and where and when the underpayment occurred and whether it's ongoing, but then give advice in relation to those remediation steps. So really, I think that's the very first thing we need to be thinking about, legal professional privilege. It can always be waived. There may be a very good reason for waiving that privilege over legal advice or over a report that is produced at the end of the day, and that certainly may be for regulator engagement, and I know Amber will want to talk about that some more. But once you've got the privilege, then it is yours as the clients to waive. If you don't set it up in the first place, you're not going to have any success there trying to, at the back end, protect the confidentiality of that information.
Okay, so then I suppose potentially the second step is how do you find out if there is or is not a problem? And Deepak, I thought I might just hand over to you to talk about the data analytics piece. How do you use that to work out if there is a problem, how big the problem is and how much the exposure may potentially be? And I suppose, you know, following on from that then, a question, you know, top of my mind is how do you then present all that huge amount of data you've determined in a way that senior executive teams and boards can quickly understand and have confidence in?
Thanks, Steph. I might start with the data component of data analytics. As most of you are actually quite familiar, we're generating lots of electronic data and pretty much every activity that we're doing, whether you're being on your mobile phone, logging on websites, electronic data has been collected. And it's very similar for employees as well. You've most importantly got timesheets, so your employees are submitting timesheets and stating how much they're actually working. But you've also got information such as when they're logging on to their computers, when they're actually swiping into the office. So all these additional sources of information. What data analytics is, it's the ability to take all of this electronic data and actually analyze it, utilizing modern techniques and statistical techniques as well. What we generally find when we are engaged at the start to try and identify if a problem actually exists, we try to approach the problem based on what we're looking for. If it's a general issue, so if the employee isn't aware that they might have a problem, we'd utilize usually things like sampling techniques to help us identify if there is a problem. So that way we don't have to look at all the employees. We can take a representative sample of the employees, limit the time period that we actually want to analyze, and then test to see if there are any general problems for that small population. From there, we can actually extrapolate. So using some statistics, we can say that what the likelihood that problem is actually prevalent across all your employees, as well as trying to estimate what the total amount of the quantum of that issue can also be. If the problems are a bit more specific, we tend to do very targeted analysis. And a good example where Christy's mentioned is the annualized salaries. An example might be, so for our legal services award, there's a clause in there stating that if there isn't a certain amount of break between shifts, the following shift has to be paid out at a time and a half rate. If you're looking at an annualized salary issue, that particular condition might be inflating the amount that if they were under the LSA, how much that employee would be paid. So what we would generally do is we would have a quick look to see employee timesheets, so we might select a sample. We'll actually then look to see what the shift, the amount of time between shifts are across that sample to see if it is actually a small amount, then therefore the following shifts will actually have to be calculated at a higher rate. And from there, we can essentially estimate if there is going to be a problem across your whole employee base in relation to annualized salaries. So there are essentially two examples of the approach we would undertake, but depending on the specific problem, there are multiple techniques. But the important thing is that we generally have to work very closely with the lawyers to try and understand the problem. I'm not a lawyer. I'm great with actually creating computer code. I can talk to a computer really well, but being able to translate some of those regulations, those large employee enterprise agreements into something that is code, we generally have to work very closely with the lawyers to actually be able to translate that into computer code, and also from a computer code standpoint, say what is actually possible. Another example is, I know there was an issue we've been looking recently where it's looking at classifying casual staff as potentially full-time employees. And some of the conditions that we need to look at is if they have a consistent work pattern. So consistent work pattern is a bit hard to define for a computer. You generally have to write specific rules stating that they are working these hours on these days. So for that example, we will generally provide a couple of statistical approaches where we can look at the spread of days and other statistical approaches to see if that is sufficient to be able to answer that questions of consistency. So from a data analytics perspective, it is quite important that we actually are working quite closely together to try and understand that problem. The second part of your question, Steph, related to how do we actually put all the results in a medium that people can actually understand. When I started my career, a lot of my work was generating tables of data, but what I did notice is people glaze over that. If you've got a big table in front of you, you're not going to be looking and understanding the details of the numbers. What generally we see these days is the ability to present that information in a medium that is interactive and engages the user so they can actually understand the problem. A good example of that actually was this morning. I was actually looking at the age and looking at the results of the US election. And if anyone's been on their website, you can see the interactive dashboards that they've created. You can drill down into the states and see the different electoral rolls and which states are voting what direction. And that's a very engaging medium to understand data. And it's a similar process that we undertake when we're looking at employee payment validation issues. The ability to be able to quickly look at the analysis. So the examples that you might be seeing on your screen at the moment, you can see there individual people that are represented on a scatter plot. So you can actually see, is there a spread of employees that have issues, or is it just limited to a couple and the majority of them are actually being paid correctly? The ability to aggregate that at a high level to see what is the total quantum for those individuals. The ability to drill down, select an individual and see per pay run if there's any particular issue, which is really useful when you're talking about remediation. You want to actually understand per employee what the issues are, and if the employee is actually looking for more details, you have that information available in something like an interactive dashboard. At the bottom left there, you've got also trends. You can aggregate information to see what I'm paying my employees. Are they above what a modern award might be? So just to be able to see that over time based on your employee shifts, what the amounts are. So it's quite important, I think, the ability to present all this information in a medium that is easily understood, because as human creatures, we rather see something than try and look at a lot of numbers. So I think that's quite important when we're talking about data analytics. But yeah, that's essentially how we can help identify problems and also present it in a way, Steph.
Okay, thanks, Deepak. So the next question I often get asked when sort of boards approach me about this is, well, how far back do you have to go? I mean, how long is that piece of string? And I'm assuming that depends what issue of remediation we're talking about. So perhaps that's a question, Christy, for you and Amber, but perhaps if you can
I might jump in first because I know my answer is much more simple than Amber's answer. So when we're talking about underpayment of wages or entitlements arising under modern awards or enterprise agreements, we're looking at a 6-year time frame that we need to go back. Underpayment claims will exist in the Fair Work Act for a period of 6 years. You'll see some employers have recently decided to investigate a longer period of time. This is not a requirement of the Act. Often employers are deciding on a 10-year period. That's because modern awards were introduced in 2010, so we've currently got 10 years for the last cohort of modern awards. But certainly that's not a statutory requirement to go back 10 years, and I have not yet seen the Fair Work Ombudsman require or be able to compel someone to go back longer than a 6-year period. Amber, how about super?
Yeah, thanks, Christy. So the starting point is that there's no limitation period for superannuation guarantee charge liability. So here I'm talking about liability under the legislation and not under a contract or under an award or an EA. So theoretically, does that mean that employers have to go all the way back to 1992 when superannuation guarantee was introduced? No, not really. The practical reality is that employers are not going to have records, details and evidence that go back that far. An additional factor that adds complexity is that it's the ATO's job to collect SGC. And the ATO generally says that they're really only going to look into the last 5 years. And that's because the obligation to keep tax records is an obligation for 5 years. But does that then mean for employers that we can give blanket advice that they only need to remediate for 5 years? Well, absolutely not. That's a very risky position. So SGC is a tax, and once it becomes payable, and it becomes payable when the required superannuation guarantee contributions are not made. So once it becomes payable, it's a debt due to the Commonwealth. And the ATO does not run out of time to collect it. So the Commissioner of Taxation has the power to collect it forever. But because the ATO doesn't have the resources to focus on everything and to pursue every dollar that's payable, and because the Australian tax system is a self-assessment tax system, the ATO has to make decisions about where the ATO is going to put their resources, their collection resources. And generally, the ATO has tended to only want to go back for the last 5 years for those complex set of reasons. But the risk landscape is absolutely changing around SGC. And the ATO has recently started reporting on the superannuation tax gap, and that has signalled a renewed focus on SGC. And the ATO has also recently changed their administrative policy on imposing penalties where there is a superannuation guarantee liability, and the new policy is less favourable to employers. So, we're seeing the ATO signalling a renewed focus on this area, and a renewed focus on imposing penalties. So, against that backdrop, if an employer makes a decision to only go back for 5 years, where that employer does have the records and the evidence go back further, that's a difficult decision to make. It absolutely attracts a level of risk. We might talk a little bit later about the personal liability of directors and potentially other senior management within companies in relation to SGC liabilities. But for some organisations, making a decision to only go back 5 years is a serious decision, and some may say that it's a board level risk decision because of the potential come back that far. The general guidance that I would give is that employers should go back as far as the evidence will reasonably allow them to go back.
Okay. So perhaps let's move to the regulators, because we've got a bunch of them that we have to consider, which is one of the unique aspects of this issue as well. Often you're dealing with one, maybe two regulators, but here you've got the Fair Work Ombudsman, you've got the ATO in relation to super, and also the ATO in relation to PAYG. You've got the State Revenue Officers or Office of State Revenue in relation to payroll, and you potentially in some states got the police as well now. So, and you know, this is in the context of decisions around, do you self-report? How do you deal with what seems to be a culture in Australia by regulators of the name and shame sort of culture that we have developed here? You know, where they want to be seen to be doing things and they want to be in the media as doing things. The consequences of self-reporting and being named and shamed. So, you know, enforceable undertakings, potentially class actions, those sorts of things, ASIC involvement potentially for breach of directors' duties, also potentially regulator audits in other areas, whether that increases that risk. And of course, overlaying all that, if you're a public company listed on the stock exchange, you've also got your disclosure issues to manage and your employee engagement issues. So I think in the context of that, you know, for the regulators, I wanted to open it up for a discussion, potentially, I suppose, Christy, for you for the Fair Work Ombudsman, and Amber, you for the ATO, about how, you know, what do you think about when you're making those decisions and how do you best handle them, I suppose?
Yeah, thanks, Steph. That's a really good question, because self-reporting is and has been fraught over the years. And I know when Amber and I are dealing with the different regulators, there are very different approaches. So we need to make sure that even though we're taking a different approach with each regulator, that the information being provided is consistent, and that the approach with one doesn't hamstring or impact the approach that we're taking with the other. But recognising that they do have to be separate approaches, because particularly for the Fair Work Ombudsman, the issue of wage underpayments and how the Ombudsman is managing those has changed, and their priority focus has changed over the years, and particularly since July this year. So while there has been and there remains no express obligation on any employer to self-report non-compliance, many employers have seen, and I've certainly recommended to many employers as well, that self-reporting was a good way to mitigate some of the risks associated with additional penalty payments and being able to really manage that, as Steph talks about, that name and shame. How do we get on the front foot with this and manage the communication process as well? Self-reporting has been a great avenue for that. Now, in the last couple of years, the Ombudsman has been quite lenient on employers who self-reported, and there would be very limited engagement otherwise with those employers and the expectations placed on them. About 2 years ago, we saw a real shift in that respect, where they made it clear to employers who were self-reporting that they couldn't expect that there would be no prosecution that would follow a self-report if they didn't comply with everything that the Ombudsman was asking them to do, and that penalties would still flow as a consequence. And they became very focused, and maybe this is even going back further than 2 years, on those court enforceable undertakings that Steph has already mentioned. And the requirements of those enforceable undertakings has really developed over time as well. They've gone from simply just fixing the issue that's been identified and making the back payments and dealing with the remediation, to demonstrating that no further issues exist, the Ombudsman sometimes wanting to impose a third independent reviewer of the audit that has been undertaken by the employer, or the Fair Work Ombudsman having their own ability to self-audit that employer over a number of years. Obviously, the payment of interest, contrition payments, often representing a percentage of the underpayment, an apology to employees, and setting up other avenues of assistance for employees as well. So hotlines for employees to report underpayments. We saw that type of approach taken in many of the 7-Eleven cases that came out a number of years ago. So while self-reporting never and hasn't been able to rule out the ire of prosecution, it was still always a good way, and the Ombudsman was very inclined to enter into enforceable undertakings with employers to manage those issues. And since then, we've seen a raft of high-profile employers, ABC, Qantas, Woolworths, Super Retail Group, Bunnings, CBA, they've all announced significant underpayments. And in fact, in the last financial year, the Ombudsman have come out and said that they've had more than 60 large businesses self-report. Now, that number seems a little low to me, 60, but they're talking of significant sized businesses there. And what's changed recently is that the Ombudsman for the latest 2020 and 2021 financial year has reset its priorities in July. They've provided a little bit more clarity around when they expect self-reporting. So keep in mind, as I said, self-reporting is not a requirement of the legislation, but the Ombudsman is now putting out their guidelines that say it's in these circumstances where we expect employers to report underpayments. So they've said they do not expect a self-report of underpayments which are from isolated payroll errors resulting in underpayments over a short period of time of up to 12 months. They don't need to be actively reported to the Fair Work Ombudsman as long as the employees are appropriately informed of the underpayment, the employees are back paid in full as soon as practicable, and changes are implemented to ensure that it doesn't happen again or that the issue has been appropriately rectified. Now, I think that is only ruling out a very small percentage of underpayments, and that is leaving a very large bulk of material that the Ombudsman is actually expecting to be self-reported to them. 12 months is not obviously a long period of time, and that what they're talking about are what are small isolated payroll issues, which is not defined in the guidance material. What they are trying to do, though, is limit the number of self-reports that they're getting. They are expressing that they have a huge workload to manage in terms of the self-reporting businesses, and I think COVID has been a big player in that. They have indicated in their priority statements that COVID and managing the impacts of COVID on Australian businesses is a real focus for the Fair Work Ombudsman, and that will be their focus for the next 1 to 2 years. I do not think that this means that employers should not be self-reporting, but I do think we need to undertake a real assessment of when is it appropriate to self-report, because once we do so, the employer is on the radar of the Fair Work Ombudsman for a significant period of time, and there will be ongoing compliance requirements associated with that. I really encourage businesses to make an assessment. Firstly, if we fall within that criteria that the Fair Work Ombudsman is setting for us, is when they expect a self-report. And then I think we need to weigh some other things into the equation as well, like the quantum of the underpayment, how many employees are affected, and what is the likelihood that this matter can be controlled and isolated. I really think there is a real benefit for businesses in getting on the front foot. If we think that an employee is going to be reporting this matter by themselves to the Ombudsman, then I would prefer to be on the front foot with that and reporting this matter to the Ombudsman before that happens. If the underpayment it may not be a huge amount of money, but it may be so widespread across the business that we cannot guarantee from our communication strategy that no one will go then and report to the Fair Work Ombudsman. Again, I want to be on the front foot with that. That's in terms of how we would manage the Fair Work Ombudsman. But Amber, I might hand over to you so you can point out the differences in terms of managing the ATO.
Yeah, thanks, Christy. So I think really similarly with what Christy's just outlined in relation to the Fair Work Ombudsman, we've absolutely seen the climate in terms of dealing with the ATO change over the last couple of years. And in particular, in the debate around the superannuation guarantee amnesty that was proposed some time ago now and that ended in early September, we saw some pretty strong concerns from some stakeholders about the idea that employees couldn't collect superannuation guarantee themselves from their employers. And that's just a function of superannuation guarantee being a tax and not a private entitlement. But in the absence of some mirroring contractual provision or something in the award or an EA, of course, employees, the received wisdom at the moment in any event, is that employees can't collect it themselves. And we saw as well some criticism that the ATO doesn't do enough to collect SGC. And I don't make any comment on that criticism in particular, but To counter some of these criticisms, the superannuation guarantee amnesty included a new mandatory minimum 100% penalty where employers don't come forward during the amnesty period, and after the amnesty period, the ATO approaches them first after the amnesty. So that penalty, where it's imposed, will at least double the liability to be faced by the employer. Now, I just want to be careful about that. That's not saying that if an employer didn't come forward during the amnesty, it's an automatic 100% penalty. What it does mean, though, is if an employer did not come forward during the amnesty and the ATO comes to the employer first before the employer's gone to the ATO, then that's where there's a potential exposure for this mandatory 100% penalty. And going to the ATO can be a step as simple as saying to the ATO, we've identified a potential irregularity, we're investigating, it's going to take some time, and to the extent that our investigation reveals there is a shortfall, we will remediate that shortfall. So it can be a step as small as that to manage that penalty risk. But the ATO as a regulator has got a pretty sophisticated range of pathways and options to help engage with employers who are dealing with these issues. So employers can absolutely still make a voluntary disclosure to the ATO. If an employer is not sure about the correct treatment of particular payments, because this is an incredibly complex area of law and it changes all of the time, and where an employer is risk averse, you can seek administratively binding advice from the ATO or indeed a comfort letter. So the ATO doesn't have the statutory power to give a binding ruling in this space, but can give what's called administratively binding advice. And you know, if you're not sure what the correct cutoff period is, so how far you need to go back, that's a question that you can socialise with ATO stakeholders before making a final decision. You can also engage with the ATO and seek no-names basis guidance on discrete issues. And some of these steps as well are really related to questions about avoiding directors' personal liability for superannuation guarantee charge as well. It goes through one of the defences, the personal liability for directors. So these questions are really quite interrelated. But the other issue just to be aware of, and hopefully we'll have time to come to this shortly, is that from the ATO's perspective, questions around SGC compliance are not in a vacuum. So they absolutely are related to the employer's broader tax compliance. So I might leave that issue there, Steph, but if we have time to come back to it, then obviously I've got some more observations on that topic, subject to timing, of course.
Can I just pick up on two matters that Amber raised, because I think it shows the difference between the Fair Work Ombudsman and the ATO as regulators. Amber spoke about the timing of that disclosure and going early and just saying, we think we've got an issue, here's a little bit of information, not much, and starting that communication process. That's not the same approach that I would be recommending in terms of the Fair Work Ombudsman. So that's where the processes really need to dovetail. Before going to the Ombudsman, I want you to have your ducks in a row. I want you to know what the underpayment is. This is subject to being able to control the communication and not having to move as quickly because we think it's going to be reported elsewhere. But if we can control that and we're undertaking a process, we've got DPAC running the forensics for us, we know what the outcome is. I want to go to the Ombudsman with a really detailed first shot, if you like, but by saying this is what we've done, this is how we've done it, this is what the underpayment is, and we've either started the remediation process or finished the remediation process. That's, I think, a real point of difference between the two. And the second is that Amber spoke of a real nuanced approach with the ATO and the different range of options. The Fair Work Ombudsman doesn't have that same nuanced approach. There aren't as many options in terms of that engagement with them. And this is not a criticism of the Ombudsman. This is a restriction, really, I think, that is born out of the legislation itself and what their particular role is. If you're reporting an underpayment to the Fair Work Ombudsman, they are going to engage with you in really only one way. They're going to either request more information if you haven't provided it, and they're going to set in place a timetable for you to provide that information, and then they're going to start the compliance and enforcement notices if you are unable to comply with their time frame. So less nuanced, less options available with the Ombudsman.
So just a couple of questions on that. So the Fair Work Ombudsman won't give, for example, guidance on the application of an award if it's in a grey area, for example.
So they do have information hotlines that organisations can call and provide specific advice. So they have different advisory parts of the Ombudsman. But when we're talking about underpayments and we think or we've identified an underpayment, we're going to a different section to deal with that with the Ombudsman.
Okay.
If we're unsure of award compliance, we need to check that first, because we might not have any underpayment issue if we're dealing with the right or the wrong award. You really need to nut that issue out first.
And they obviously don't share information. So, for example, in my world firm, they will share information between the regulators. You don't have that happening here. There's no information sharing protocols.
I haven't seen that they share information. Amber, I've never seen anything go to the ATO from the Fair Work Ombudsman.
Yeah, so look, yes, it's possible, but I have to say I haven't seen it myself. And I think, at least from an ATO perspective, I think part of the reason for that is possibly that when you're in a voluntary disclosure or a low-risk compliance style engagement with the ATO, so you're more having a conversation, the ATO is not putting the employer in a high-risk basket at that point in time. So the Commissioner is just really going to want to be part of the process of driving the remediation, rather than focus on providing information to other regulators. So it is possible. I haven't seen it. What I have seen happen though, almost as a matter of course, is the giving of information to the various state revenue officers, because there will almost always be a payroll tax issue, but that tends to happen at the end of a process and usually not during a process.
Yeah, okay, thank you. So if I can come back to you, Deepak, because one of the other things that certainly I've seen, and I'm sure you've all seen, is how do you get the data? So, for example, in the context of a company buying another company that might be small or privately owned, although larger and privately owned, do they even have timesheets, or if they do, are they manual, and how do you get around all those issues, I suppose, Deepak, when you're looking at the data, when it's really not well kept, not well organised, and a lot of it might be manual?
Yeah, I'll start off by probably saying that this component about extracting data is probably the most underestimated aspect of any employee validation. A lot of clients think that they have their data sitting in a nicely accessible payroll system that they can just take out and start analysing straight away. Generally, you'll find there's quite a bit of complexity when we start looking at what data is actually there and how it is stored. Firstly, a lot of large organizations have multiple payroll systems, or over time they have transitioned between different versions or different payroll systems. And when that transition happens, data doesn't necessarily translate one-to-one between those systems. And therefore the data export-import might actually have changed the data, or the data might have actually been aggregated. So you don't have that detail that you need to be able to run some of these calculations. Secondly, we find as well, over time, the configuration of systems change. You might be using pay codes historically that are never used again. And when you look at the different, or what the pay code was used for, the employee might not actually know what that pay code was used for because it was used so long ago. So all these different issues generally are identified when you're looking to extract the data. And it's very hard to actually know what some of the problems are until you start actually digging in and looking at it. One of the other aspects of the data extraction process is also standardizing it. If you do have data coming from multiple systems, being able to create a nice data set that we can actually run our analytics model on, that actually does take some time. When you've got multiple systems, they store data differently. So yes, it might be payroll data, but the way that they actually store that data is very different, and therefore to be able to bring it together is quite a bit of effort. Generally, we also find when sourcing data, there are other aspects of the business that generally have to get involved. IT security is a good point where generally we'll have to deal with IT security to try and understand Firstly, how the data is being secured, what the data is being used for, and how it's actually being transported. And there's usually policies that will require assessments of the different infrastructure and different technologies that are being used to analyze the data. So that does take some time. There are also data governance policies at most organizations, so who can actually access the data, what it can be used for, who needs to be notified. There's usually a lot of paperwork involved with that. So the process itself of getting the data does take a while because of all these additional considerations that need to be looked at as well.
Yeah, thanks. Sorry, go on.
Sorry, I was going to say the last aspect of it as well, there's a lot of complexity actually getting data out of the system. You might be familiar with actually running reports out of the system, but those reports generally can't be extracted for your whole employee base for a large period of time. So you have to generally go to the database of that actual system to be able to export in bulk. And the way the data is stored in those databases aren't necessarily simple. It's not just kind of payroll records. It might be split into different sections. And the ability to join all that together does take some time as well. So there are some of the complexities that we generally have to deal with when we're looking for the data we need.
And I think from my perspective, sort of at the board level, for anyone managing that, I think you can assume whatever time you think it's going to take to extract this data, it's going to take longer. So when you're setting expectations around timeframes and work streams, just a warning not to underestimate that, because even with large sophisticated organisations who you would assume it would be easy, Christy, you found significant issues, right? So I think you should assume that's going to be a task that will take some time. Okay, I wanted to move then to some of the risk and governance issues that we look at here, which is a slightly different lens to this issue. Certainly from my perspective, before I turn to sort of Christy and Amber about some questions, you've really got to firstly consider the director's duties question there, and we're almost at the point with this issue, given pretty much everyone's got problems when you look into it, some are small but some are big, that you probably need to be doing this review if you haven't already, and I think you need to couch it in that director's duties context. And we haven't seen ASIC involved in this area, but I don't think it's a stretch for at some stage a regulator or the federal government to ask ASIC to look at the director's duties issue there, particularly in egregious cases. It's a test case, and they will be pursuing things like banning orders. Obviously, we have penalties under the other regimes, but they will be focused on banning people from being directors where this sort of hasn't been done properly. And I think the other thing that has been discussed at boards is, well, can we do it internally or partially internally? And I think the challenge with that is the board needs to think about conflicts here, because what you've got is a HR team that's basically interpreted the awards and the enterprise agreements, potentially been involved in negotiating them if they're enterprise agreements, who have said how it should be applied, who are then it's a self-review risk, really, if you want to think about it from an audit point of view, is you're actually asking them to critique their own work product. So I think that pushes you to really, if you want to deal with that issue, to go to an external review for this stuff. So I suppose that's the sort of common issues that I deal with. But I wanted to hand over also to Christy and Amber, because I'd like to sort of talk to you about what is the potential exposure from the regulators for directors and senior management teams in this area as well.
Yeah, well, from the Fair Work Ombudsman's point of view, I know that they are increasingly looking to involve as respondents to underpayment claims directors of organisations. Now, there's a number of reasons for that, one being that the company often goes into liquidation, subject to how large the underpayment is. So they're looking to recoup the payments, the underpayment wages and the penalties directly from the directors and officers of the organisation. The provisions of the Fair Work Act that allow them to do that talk about the individuals being knowingly concerned in the contravention. So that's the bar that needs to be reached. And yes, it does sound like a relatively high bar, but I think frankly, when you put that in the context, as Steph was saying, as a director of an organisation with director's responsibilities, if a board is aware of underpayments and has made relevant inquiries but does nothing about those underpayments, then I think that brings you into the realm of knowingly concerned within the underpayment. Then I suppose the next question is, what if the board does not know? But the issue then is, have you made the relevant inquiries? So the legislation, in particular, the Fair Work Act, talks about when you are not knowingly concerned or when you don't have that active knowledge of a particular underpayment. They say an implied knowledge or constructive knowledge can be used in the circumstances. So they talk about a willful blindness.
So a head in the sand sort of.
Exactly,
yeah.
Exactly. Yeah. This willful blindness, the turning the blind eye, the not paying attention to the risk and attempting to manage it. So that's where the director and officer liability comes in. So it's not just the directors, it's those in senior.
So who are the officers, CEO, CFO? What about head of HR? I mean,
Yes, so they'll rely upon the Corporations Act definition for officers there, but they have been prosecutions of HR managers who have reported directly to the CEO and about their involvement in the contravention. The Fair Work Ombudsman is actually going further as well. They're looking for boards of parent companies. So if there is an involvement there or an awareness of underpayments at a subsidiary level, that board, exactly. Yeah. Those boards can also be liable, and even further afield, again, they're looking at your third-party advisors as well. So accountants, a recent case came out 2 days ago about the accountants for an organisation who really assisted in the contravention. It was quite a serious matter where they had created documentation to reflect the payments that had been made and not the reality of what was owing. So that was a particularly willful case. So the accountants in that case were liable as well as third parties.
Amber?
Yeah, thanks, Steph. So similarly, there's I suppose it would be a similar cohort of individuals who can be made personally liable for superannuation guarantee charge that isn't paid. But I think it's a much lower bar for that personal liability to arise. So it's just that liability can arise without anything more than just the SGC not being paid. So the SGC becomes payable and it's not paid. That alone triggers the Commissioner's power to issue the particular form of notice that gives individuals, directors, officers, other senior managers and others concerned in the management of the company, the personal liability. It is extraordinarily difficult for personal liability under directors' penalty notices to be avoided. It's notoriously difficult. And the only way really to remove that personal liability is to either pay the SGC or to cause the company to pay the SGC. There are very limited options otherwise as a general rule. However, as far as SGC is concerned, there is one other pathway, and that is to prove that the company had a reasonably arguable position, so a legal technical basis that establishes there was a proper legal basis to not pay the SGC. So that's not proving that the SGC wasn't payable at law. That's a bit different. This is recognising the real complexity, the real legal complexity, and acknowledging that in some of these issues that a company can take a reasonably arguable position, and it just happens that the Commissioner thinks that they're wrong. But the company must also be able to demonstrate that they took reasonable care as well. And this is where we start getting into some of these questions around bringing in external advisors as well as doing the internal reviews, how often that should happen, and how broad the scope of those reviews should be, so as to ensure that the board and senior management are comfortable that the company has taken reasonable care. So in the event that there is an issue in future, the company is going to be able to avail itself of this particular exception so as to demonstrate that it did take reasonable care. In practical terms, though, This pathway by the ATO, so choosing to put personal liability on the directors, is really very rare. Overwhelmingly, what tends to happen is it's more of a dialogue between the regulator and the employer, and the correct and sensible outcome will be reached. So yes, it is absolutely possible, but for the overwhelming majority of employers, an SGC issue won't go down this path.
Thanks. So look, we've only got a few minutes left, and I sort of want to wrap up as well. So before, just quickly, Christy, before we finish up, I think one of the other big pieces about this is your communications with your workforce and your stakeholders. So, your shareholders, others, customers potentially. We know supply chains are looked at now as well. So, one of your customers is a big organisation and you have some real issues here, how they perceive you. So I think you've got to look at that whole piece. How do you, and I suppose you've got the unions as well potentially, so how do you see that all managed?
I think every communication strategy really needs to be quite nuanced based upon the circumstances of how the issue came to your attention, where your biggest risk factors are, how you manage those first, and then you move to those other stakeholder groups. You've also got to ensure consistency with those messaging. You've got to assume that anything you're giving to the employees may also end up with your customer, your supplier base, your key stakeholders, your shareholders as well.
7-Eleven, right? I mean, exactly. They were public, so.
Yeah. So if it's an issue that's been brought to your attention by a particular employee or group of employees, or the workforce as a whole, there would need to be some early communications with those employees. You'd really be wanting to assure the employees that you take it seriously, you're looking into it, and that you'll keep them advised of the process that you're undertaking. And if you give firm commitments in relation to time, make a note of those and make sure we can keep to those time frames, because that's the first thing that an employee, and in particular a union, will remember as well.
Well, it's when the data analytics.
It's really important
that you don't underestimate
and we know how long this is going to take. It doesn't mean we can't give regular updates to employees and let them know that time's pushing out for us, but you don't want to be doing that too often, because then you start to break trust with those employees in terms of the process that you're undertaking. So every communication strategy will depend upon how the issue is brought to your attention and how long you think you can manage it internally without it getting to any of these key groups. And I think that time frame is really decreasing with the more underpayments we see in the public arena.
Yeah. And as I said, I think there's a broader piece around, customers, suppliers and the market if you're listed as well, and how you manage all of that. So look, I think that brings us up close to our closing time. There's also a whole piece here around ongoing compliance, because as you know, terms and wages change all the time. So if you're going to do this work, how is it that you can then put in a robust system around ongoing compliance? So I don't think it sort of ends at the audit, really, to my mind. So I think as a group, what I've suggested is we perhaps do a second series of this around what does that ongoing compliance piece look like, and what are going to be the expectations in relation to that going forward? Is it a yearly review, or what does that look like, and what are the regulators going to think is reasonable in that area? And then any questions that people have or things that you would like raised in that second session, please feel free to send them through, and what we'll do is we'll have a look at them and perhaps spend a little bit more time in the second session on some of those issues you would like teased out a bit more. So in closing, I suppose personally I'm pretty proud of the Clayton Utz offering, which is a combination of legal and technical, and I think it's actually a bit unique in the market, that those strengths are combined in a way that ensures you're best protected. But I just wanted to thank you all for your attendance today, and hopefully we'll see you again at the second session as well, and able to address some of the questions that you've had at that time. So thank you, everyone.